We're with David Shapiro. David is a criminal defense attorney in San Diego, California. He's agreed to answer some questions related to drunk driving. With that said, David, let's go into the first question that was posted online. I was recently bailed out for drunk driving. What would it cost for you to represent me?
Well, that's a good question. A lot of it will depend on whether the case is filed as a misdemeanor or as a felony. Obviously, the consequences for a felony would be far more significant than the consequences for a misdemeanor. If it's a misdemeanor, is it a first time, a second time, a third time DUI? And also important is, where is the court located? Is it downtown San Diego? Is it somewhere outside of San Diego County? Is it somewhere within San Diego County but not near downtown, like North County or El Cajon or Chula Vista? So, a lot of those factors go into it. Is trial going to be included on the retainer? Has the DMV hearing already come and gone? So there's very, very many variables that can affect it. Generally speaking, DUIs, at least with my office, are $2,500 and up. As low as $2,500 for something pretty straightforward, first-time DUI. At a courthouse with a location right near my office, and as high as I've charged as high as $15,000, $20,000, depending on the severity of the case, depending whether or not the case went to trial. Even a first-time DUI could be a felony DUI if someone was injured. So there's way too many factors. But generally speaking, obviously we're not married to this because it's my office, and we could be flexible to a certain degree. $2,500 and up for misdemeanor DUIs.
Okay. Next question was, I was pulled over when visiting San Diego from Los Angeles. How will this affect the process for me?
Well, since you live in Los Angeles, you definitely don't want to have to come back for court. So you definitely want to hire a criminal defense attorney here in San Diego, particularly if you can afford to do so. Most, and I say this with an emphasis on most, misdemeanor DUIs, you do not need to be present for court. The attorney you hire can appear for you at pretty much any and every court appearance. The factor in LA really doesn't complicate things too much. You still have a California license. We're still dealing with the same DMV. Any and all conditions of probation, assuming you're even convicted in the first place, could be satisfied up in Los Angeles County. So you shouldn't have to worry about having to come back to San Diego for court. You should not have to worry about having to come back to San Diego in the event you're ultimately convicted. But something to keep in mind if we wind up running preliminary motions on your case, particularly if it's a misdemeanor. If it's felony, you need to be here. But motions, and if the case goes to trial as a misdemeanor, I'd want you here. But the factor in LA doesn't complicate things too far or too much, because you're really not too far away.
Okay. Next question. I took a breathalyzer and failed. Do I have options?
You always have options. That's the most important thing, whether it's a DUI or any type of case. You always have options. And the other issue is, well, what's failing a breathalyzer? The law in California is, as it relates to your blood alcohol level, is you need to be, in order to be proven guilty beyond a reasonable doubt, be 0.08 or higher at the time of driving. So just because you're 0.08 or higher at the time of the breathalyzer test does not necessarily mean you were in fact 0.08 or higher at the time driving. Doesn't necessarily mean that there weren't other outside factors or variables that may have affected the breath reading. So there's no such thing really as pass fail. Obviously a significantly higher reading above 0.08 isn't good. It's a lot more stuff to overcome and a lot more issues to deal with. But you always have options, whether or not the option is resolving the case for a minimum DUI sentence, irrespective of your blood alcohol level, whether it's reducing the DUI charge to something else, or whether it's fighting the case and litigating the case at a suppression motion, or taking the case before a jury to trial. You always have options. The issue is what you believe is in your best interest, based on all your options that your attorney should be advising you that you have.
Okay, and next question. My son is in jail for drunk driving. This is his third DUI, and they're talking about significant jail time. Do you have experience in dealing with this specific type of situation?
Yes, I absolutely do. First off, assuming this is a misdemeanor, third-time DUI, and assuming the 2 prior DUIs were regular misdemeanors, no injury, nothing like that, your son would be facing, if he were to be convicted, 120 days to 1 year in jail. So, it is a decent amount of jail time. Based on your post, it appears that he's already in custody, accruing credits and generating custody credits. But, there's a couple of things you could do. It's a lot easier if the client's out of custody, as far as being proactive in what I would advise the client to do to show the court and to show the prosecutor how serious he or she's taking the case. When they're in jail, it's a little bit more complicated because you can't have them enroll for a DUI program, you can't have them in substance abuse treatment, but possibly we can condition a release from custody to a residential rehab facility, which will go a long way in trying to negotiate a favorable outcome, assuming settling a case is in his best interest. Just because he's in jail, just because he has 2 DUI priors, doesn't necessarily mean that he doesn't have a good case on the 3rd DUI. It may get complicated a little bit, however, if he was still on probation at the time of the 3rd DUI for the 1st or the 2nd, because then you would be dealing with the probation violation on the 2nd time DUI, where he could get up to a year just on that alone in jail. So, you don't want to win the battle to lose the war. If the main objective is to get him out of jail, you might be litigating the 3rd DUI. You might even win the 3rd DUI or beat the 3rd DUI, but you can still be held in violation of probation for the 2nd DUI, just for whether it's driving without a license, whether it's driving with any measurable amount of alcohol in your system, no matter what the case may be, and you might wind up in the same position. So that's something that we need to obviously analyze and find out what he's in jail for, how recent the priors are, and plan accordingly from there.
Understand. And the final question we have is, how many DUI cases have you won?
Well, I like to think all of them, but it all depends on what's a win. Personally, as a criminal defense attorney and someone who's handled over 1,000 cases in my career, at this stage, I think a win is getting the best outcome possible given the facts of the case. If I'm dealing with cases that there's no issue with driving, there's no issue with blood alcohol level, well, then what's a win? Are you going to go to trial and get hammered, or are you going to get the best possible outcome on the case? I've won several DUI trials, whether it has to do with arguing that my client wasn't driving, or it has been proven that my client was actually driving the vehicle, whether it was a blood alcohol level of 0.08, 0.10, 0.26, whatever the case may be. I've been successful. More importantly, my clients have been successful at taking those cases to trial. I've had suppression motions granted, which ultimately dismissed DUI cases in its entirety. We've had felonies reduced to misdemeanors while the case was ongoing. So what's a win? A client may think, a lot of times people may ask me too, you win all these cases. Like, well, maybe not get a not guilty on every count, but it all depends what a win is. If you accomplish your goal, which is to get the best outcome possible given the facts of the case, then it's a win. And I like to think I'm successful in pretty much everything I handle.
Excellent. Well, if you have any more questions for David, please feel free to he's agreed to answer comments at the section below. So just down in the comments section, post your question. David will get back to you with his answers. With that said, David, thanks for your time.
Yeah, my pleasure. It's important to note, that no matter what your blood alcohol level is, no matter how bad you think you might have failed, so to speak, a field sobriety test or a breath test, you definitely do have choices. You definitely will have options in the attorney you hire. You possibly have defenses you might not even know about. And at the very least, you want to make sure you hire someone that knows what they're doing and has the experience to put you at ease. Because if you're going to have to eat a DUI conviction, you want to know, hey, my attorney looked at this. He or she knows what they're doing. They've exhausted every remedy. And then you could feel a little bit more comfortable about resolving your case for a guilty plea if that's the route the case goes. So, you always have options, and I would encourage you to utilize those.
Thanks, David.
Thank you.